thank you very much for the invitation. I'm excited to be here. I'm going to be the first one after lunch, so I'll try to keep you all awake. This is a paper joined with Matt Collin from the EU Tax Observatory and David Sacconi, who's at George Washington University. And the paper is titled The End of London Grad, Beneficial Ownership, Transparency, and Offshore Property Investment. So we're going to move from banks and look at real estate in this paper. And if you can't see it in the back, we have a picture of a washing machine, and inside this washing machine is Trump Tower. And it's supposed to symbolize basically the big draw of real estate for illicit money and illicit financial flows. And real estate really is a prime destination for this type of money for different reasons. One is that it has very high values, right? We have lots of properties in the biggest cities in the world which are worth a lot, but at the same time it's hard to determine exactly how much a property is worth. So there's lots of opacity. You can hide money and it's unclear exactly how much you're hiding. There's lots of cash purchases, so purchases are not easily traceable with these information exchange programs that we have. And the people involved in these transactions usually don't have to comply with anti-money laundering rules, right? The lawyers that take care of property transactions are much less, or they don't have to comply with these AML rules. They don't have to file SARs similar to banks or other entities. And in addition to that, we know that lots of these properties are not owned by individuals officially. They're owned by companies, often shell companies, that are ultimately used to hide the owners of these properties, right? So many of the high-worth penthouses in New York or London, what we're going to look at later, they don't actually have individuals as owners, but some kind of company that then might be registered in a tax haven, the Cayman Islands or elsewhere. Oh, okay. Oops, sorry. We're stuck. Okay, here we go. Now, real estate in general is a prime destination, but as we know from many other works and many books by Oliver Buller and others, London specifically and the UK in general are really, we see a lot of investment of illicit funds, right? It goes so far that you could actually take a tour for a while in London, a bus tour that would drive you around called the Kleptocracy Tour, and it would drive you around and point out the mansions that would belong to certain oligarchs or other kleptocrats. And we know from investigations by Transparency International or others on the Panama Papers that there are lots of properties linked to PEPs, to oligarchs, to other kleptocrats in the UK and specifically in London. Right? We also know that many of the companies that are used to own these properties are registered in tax havens, so actually hiding or really hiding the ultimate owner of those properties. And some work by others here in the room has shown, right, that we also saw a rapid inflow once the CRS came into effect and the automatic exchange of information happened. We actually saw that a lot of money directly went into UK property. And when I show you some raw data later, we can actually see a little spike of that in some of our data, the end of the effect that Bomar and Terry show. Okay, so we have some evidence that we've seen today already, right, that transparency works, that the AOEI reduced offshore deposits, that the threat of beneficial ownership reduced holdings or UK holdings in overseas territories. And when the Scottish limited partnerships, or when the ownership rules were introduced for Scotland, we actually see in the raw data really a collapse of these type of firms. In our other work, we do have some evidence that transparency doesn't always work. So we look at geographic targeting orders in the US, which introduced beneficial ownership requirements for a specific type of real estate transactions. And in that case, we actually do not find any effect. We believe, and this is just a hunch, that this might be due to the fact that this US policy was not public. So the register in that case was not public. The beneficial owners would only be reported to FinCEN, and nobody really knows if FinCEN did anything with that data or if there was any enforcement. So there's some evidence that it works. or lots of evidence that it works in the case of banks and AUI, but some evidence that in some cases it doesn't. Okay, so in this paper, we're going to look at a very specific policy that came as a shock now 4 years ago, right? So there was the economic crime bill that originally was declared by David Cameron, which was supposed to introduce beneficial ownership to overseas company owning real estate or property in the UK. Now, basically, this bill was originally introduced in 2016, but it was basically dead in the water. Nothing happened. I think probably everybody had forgotten about it until the Russian invasion of Ukraine in 2022. And then suddenly, in early 2022, the bill was reintroduced and fast-tracked in February and then passed in March. So within 1 month, basically, the bill reappears and is passed and comes into effect. Right? So really nobody was expecting this. It really came as a shock, as we like in economics for our causal identification. So what this bill did, or does still, is it set up a register of overseas companies or overseas entities that own property in the UK. And this register should list all the beneficial owners, so anyone owning more than 25% of the company that own property in the UK, right? And the important part, we think, or we believe an important part of this bill is that this registry was public. So starting in August, you could go onto the registry website and you could basically Google or search for the companies and look at the beneficial owners. And it would also be retrospective. So any property owned that was bought after 1999, the individuals would have to declare the beneficial owners. In the law, it introduced fines and even prison sentences. So if you were not complying with the law, you could be fined up to £2,500 per day or go to prison. I'll talk about this in a little bit. We haven't really seen that. So there might be some issues with that. And importantly, if you were to sell your property after February 2022, you would still have to declare beneficial owners. Okay, so as I mentioned, right, this really was a shock around this expectation of anonymity of any property purchases because it was really unexpected and came kind of out of nowhere. We believe that this would then be consistent with basically a shock to the probability of detection, right? So if you were either known to the tax authority, but you have assets that are hidden in this way, you were in danger of that being found out, or if you are maybe a sanctioned individual who is hiding the property that you're owning in the UK, you might be found out because you're now revealed in this beneficial ownership registry. We also believe that the public nature of the registry is important, right? Because we have already seen a number of investigations by journalists, by TI UK and other NGOs into the actual owners of these properties. So the ability of civil society and journalists to look into this, we really think has an important impact. So the question that we ask is, did this bill lead to a deterrence effect, right? And did it basically change the behavior of individuals trading real estate, and did it lead to a decrease in secretive offshore investment? Okay, so what we want, right, is basically panel data on property transactions owned by overseas company. Unfortunately, that doesn't exist. So we build it from these two main sources, the OCOD, which is the database that registers any property owning that is owned by overseas companies. And basically it has a date of when the property is owned by the company and when it's deregistered for a certain company. And then we combine that with the CCOD, which is the same thing but for domestic companies. Now, what we do is we try from that to aggregate that or combine that basically into transaction data, right? So we can observe if an overseas company is selling to a domestic company, because it occurs in both databases, once as a seller on the OCOD and once as a buyer on the CCOD. We can observe the other way around again because it happens in both, but what we don't see is any transactions basically to natural persons, or we only see that as deregistration in either of these databases. So we infer from if a property disappears out of OCOD, say, but does not appear in CCOD, right, then it is sold to a natural person. In that case, there's a danger of a lag, so we basically can't pinpoint the exact sales date. Then we combine that with price paid data from the land registry to detect and predict prices, and we use leaked data sets to determine risk categories of which individuals might invest through which tax havens. I'll get into that in a little bit more in a second. Okay, so what we want to do is a very simple difference in difference design. We've already seen that a couple times today, but basically the idea is that we have this haven indicator, and beta here is our treatment or our treatment effect, right? Our outcome is going to be transactions at the jurisdiction level, and so the jurisdiction is which jurisdiction in the world the company is registered in. So I are all the countries in the world, basically, and then we count the number of properties that are sold or bought by companies registered in that jurisdiction. T is the time indicator, and then haven is an indicator 0 or 1 for whether that jurisdiction is a tax haven. And for our main specification, we use the tax haven list by Minkoff and Miete, but we have some robustness checks with others. And then we have jurisdiction fixed effects and time fixed effects. Right? And so the idea is that only companies or more companies registered in tax havens are the ones that are basically threatened by this reduction in anonymity. Right? The ones that are, if you have German companies buying property in London, they're probably less likely to be secretive, and so they're less affected by this new beneficial ownership registry. So then we look at the impact of the ECB, the differential impact for companies that are registered in havens versus companies that are not registered in havens. In a few slides, we'll also talk about, we're going to look at haven-specific differences, so havens that are very much used by Russians or corrupt individuals versus others to kind of determine whether the effect that we're seeing is only due to Russia or Russian sanctions, to distinguish that potential. And then lastly, I'll show you some effects where the prices were changed. Okay, so just to look at some raw data, we have here basically the proportion of purchases made by overseas entities, right? And you can see here's where the bill comes into effect, and we kind of see even in the raw data a decrease here, right? So we see that this happens not only if we do complicated statistical analysis, but also just looking at the raw data. Now, one comparison group might be domestic companies, but we don't have enough basically differentiation to do a difference in difference analysis here. But if we look at just the raw data, you can clearly see this differential effect, right? We have similar kind of parallel trends. This is the spike that we think is kind of the end of the AOEI effect. So there's a big spike here, but we see clear parallel trends until going up to 2022. And then you see this decrease in foreign corporate investments, either the number of titles or similarly if we look at the value of properties, but you don't really see this decrease in domestic investments or by domestic corporations until later on. Similarly, we can compare foreign individuals to foreign companies, right? Only the companies are affected by the ECB. And again, we have pretty nice parallel trends, again, in the raw data, but then we see this steep decrease in foreign companies purchasing property, but not when we look at foreign individuals, both in value again and in the absolute, in the number of titles. Okay, so turning to the difference in differences results, right? So here we look at the total number of properties purchased, and sorry. Okay. Yes, and we can see clearly the strong effect after the registry comes into effect, right? Even stronger after the registry goes live in August. So there's a clear decrease in number of properties and in the value of properties bought by companies that are registered in tax havens compared to those not registered in tax havens. We have a number of different robustness checks, different specifications with other outcomes, IHS transformed, number of properties, number of transactions, the volume, a binary indicator. Basically, we find a consistent effect throughout all these different specifications. One thing that was a little bit surprising to us is there's no effect on sales, so we don't see anything that people are trying to get rid of properties. So the stock of properties owned by offshore companies is fairly constant across the whole period. We only see that the number of purchases is going down, but the stock is essentially unchanged and there's no real sell-off. Okay, then one thing we immediately thought about, okay, this might just be about Russia, right? Maybe it's Russian sanctions after the war in Ukraine, and Russians are pulling out or Russians are not buying anymore. So we wanted to get at this, and so what we do is basically we rank the different tax havens by who invests or who has most money in those havens based on ICIJ data, and we basically split the havens into those used by people from the most corrupt countries, those most used by Russians, and those used by people from CRS signatories. And basically, what you can see is that the effect is consistent across all of those. We see the fastest effect of Russians, so this is the blue lines here, right? So we immediately see that in February, which is not surprising. But for all of the different havens, this continues, or we find this consistent effect. The other robustness check we do is we remove, basically sequentially dropping those havens most favored by Russians and see when our effect disappears. And you can see basically we have to remove over 11 havens to get a non-significant effect. So we believe the effect is not just due to Russians pulling out of London, it's a more general effect that's distinct from the sanctions. As I mentioned before, we do not find any effect on prices. We have some hunch that maybe this is due to that there are relatively few properties and they're high-end properties, so it's unlikely to find average effects on prices. But in all our specification, basically, there's no effect on a decrease in real estate prices. Okay, so to summarize, we find significant evidence that there's a contraction in purchases of offshore companies owned in tax or registered in tax havens. This is more pronounced in Russian favored havens, but also true for all other tax havens. And I haven't shown you this, but in the paper we show that there's no evidence of any substitution into corporate entities, so shell companies or companies that might be more likely shell companies at the domestic level. But the total stock is not significantly decreased, and there's no effect that we can detect on prices. Now, there are loopholes, and this article came just out 2 days ago in the Times in the UK. A lot of the companies that are registered are not necessarily actually revealing their beneficial owners, even though they are in the registry. So a lot of them might be hiding as trusts, where the ultimate beneficial owner is still not detectable. You could dilute the threshold, right? So you have no owner that owns more than 25%, and so you're not required to give those out. Nominees are still permitted, and we see quite a bit that the beneficial owner of the company is another company or a nominee, and almost 9% of those in the registry don't provide a beneficial owner at all. In the paper, we show some analysis that when you actually look at tax havens versus non-havens, the overall declaration of BOs is relatively similar. But then once we dig deeper and look at trying to find the natural person that's behind the BO, you can see that in tax havens, that rate really declines. So a lot of them are trusts or other nominees versus non-tax haven, that number stays relatively constant. So we believe that there's some evidence that transparency works, right? The purchases fell. It's not just Russia. And we believe that the public nature of that registry is really important and contrasts that to the results in the US. But again, the stock is relatively similar, so we don't see that the actual number of offshore-owned properties is decreasing significantly, and these loopholes that I just mentioned remain. implications. Yeah, so we believe public registers are more effective than the confidential nature of the registry that we see in the US. We believe extending this to trusts and closing the loopholes will be important, as well as increasing the verification capacity at Companies House and actually finding people. So as I mentioned earlier, I think so far there have been reports of about 3 or 4 fines, even though many, many people are avoiding to declare their BOs. Yeah, thank you.
Hi, Andy Summers from LSE. Really interesting presentation, thanks. I just wanted to ask about your definition of tax havens and what role you think tax plays in this story, because there are obviously other non-tax motivations potentially for keeping ownership secret, and also on the sort of side of classifying countries. I know that's kind of a bit of a fraught exercise. There's lots of different indexes you could use. But there are some countries that are high secrecy but not especially low tax, and vice versa. So, yeah, interested in how you'd think about that.
Yeah, thank you. So 2 things. So one, I think I would say in my opinion, maybe Matt disagrees, but I think the tax angle is less important, probably. And so if we actually look at so here we have kind of the Russian favored havens, right, which is the blue, where the effect is immediate and strongest. The effect that is kind of weakest is the CRS participant favored havens. So that would be the tax, maybe the tax angle. So we kind of think it's more about the secrecy. And yes, the lists are difficult. So for example, the US is not included in this, and Delaware might, right, or Delaware, Wyoming might be seen as tax havens. We tried a couple of other lists, and the results are kind of robust to that. But yeah, it's a good point.
Hi there, Mike Hegarty from FCDO. One of your final policy implications, thanks for this research, by the way, which we refer to quite frequently. One of your final policy implications was the need for cross-border cooperation. So could you say a bit about what aspects of your research kind of led you to that conclusion and where you might begin?
Yeah, that's a good question. So I think basically, actually, I think, yeah, there is this idea of having kind of something similar to the AOS, to the CRS, right, for real estate and beneficial ownership. And I think that would be kind of the ideal area to move in, I guess. In terms of where we would start with our research, it's, I think, yeah, I'm not sure. It's difficult. I mean, the part of the US that I talked a little bit about is, in some sense, right, it would be nice if these beneficial ownership registries are not just contained in one country, right, but also available to the authorities in other countries, and optimally available for researchers, where we can compare kind of who's in which and the movements across these beneficial ownership registries across countries. So yeah, imagine we could look into the US black box. Could we see movements from declarations being made in some countries to declarations being made in other countries, for example? That would be really interesting.
Thanks for the paper, really interesting. I'm Zorka Millen, a policy director at the FACT Coalition. I was surprised by your finding that there's no effect on prices. And I know you kind of speculated because it's a small number of properties and they're high end. And I don't know, I wanted to invite you to maybe elaborate on that a little bit, because it just seems counterintuitive. I mean, if you take off, you know, this, there seems to be a reduction in demand, right? Because the Russians and all these other people who were previously in the London real estate market are no longer there. So, yeah, what is happening? Is this just who is benefiting? The rich English people who want to buy these properties, or what exactly is going on? How could there not be some drop in prices? Thanks.
Yeah, thank you. So this is something we're struggling with in terms of the empirical analysis, because it's very difficult to identify kind of the correct treatment, or not the correct, which units are treated or not, right? And then we have the issue of, do prices decrease in the top tercile, but the average prices that we're looking at do not. We hope to do some additional analysis where we actually look at more of the high-end regions, and so it might be that we can find an effect at like the very high end, right? That high-end properties, the prices are actually decreasing. And in that case, I guess it would be that the rich are benefiting from lower property prices. But I don't necessarily think it's surprising that we don't find an effect on average prices, right? Because the properties these people are buying are not the ones that we would buy. And so it's not surprising that there's no effect kind of in the average price. Yeah, I think that was supposed to be the last question. Okay. Sorry.
Hello, everybody. Thank you for including this paper on the program. The title of this paper is The Transparency Tax, Discouraging Firm Ownership via Tax Havens in Ecuador. And this is joint work with Pierre Bajas, hi Pierre, and our co-author Alex Bajania. So there is an extensive literature that we all know that documents the negative externalities that tax havens impose on other countries. We've studied this extensively from the perspective of tax base erosion. There's a wealth of work that shows that tax havens hold a great deal of global household financial wealth in a manner that's also largely attributable to top earners. To say that tax havens enact a negative fiscal externality, but also undermine the progressivity of national tax systems. But I think another role that's played by tax havens that is really front and center in the conference is the role that tax havens play from their lack of transparency. That's been argued to facilitate criminal activity and the inhibition of enforcement of both multinational and domestic law abroad. And importantly for our purposes, this lack of transparency really inhibits our ability to, one, learn about tax havens, but also inhibits our ability to learn about the design of anti-tax haven policy. So, in this respect, there are still many open questions that characterize this field. You might think pertaining to evasion elasticities involving tax havens, but also how different types of tax haven usage responds to reform. And we all know that there has emerged a predominating perspective of global policy coordination among countries to deal with this issue. And we've seen many work studies that show, in some respects, broad effectiveness, but also somewhat mixedness and potentially large avoidance margins and evasion margins. So this paper is going to be adopting an approach of asking whether it's possible for individual countries to pass unilateral policies in discouraging tax haven use and increasing offshore ownership transparency. So this question brings us to the setting of Ecuador. Ecuador is unique in that in 2015, they placed what was a novel anti-tax haven policy consisting of a 3 percentage point corporate income tax surcharge on firms observed to be owned via tax havens. You should think of this type of tax policy as aiming to accomplish two things. First, decreasing evasion of Ecuadorian personal and corporate income taxes via havens, and two, improving offshore ownership transparency. For reasons I'll get into in a moment, we should think about this policy as really affecting haven usage, really involving more closely held firms that we could think of as owned by top earners. This is an important margin to study because there's some work that shows that a substantial amount of evasion involves these types of closely held business entities. And just to make this a little bit more concrete, I just wanted to plant in your mind the platonic firm that you should really have in mind here. We're not really talking about multinationals. You should perhaps be thinking about boutique firms that are perhaps highly specialized and engaging in service provision, for instance. This policy is going to provide us the quasi-experimental variation for estimating the behavioral characteristics of offshore tax evasion and the impacts of regulating tax haven usage on business activity. Importantly, this policy was introduced in a context with ownership, with pre-existing ownership reporting data. And this is important, but and at the time it was quite unique to the Ecuadorian setting. But as we all know, these types of data have very much proliferated, and so this is very much a type of tax policy that other countries can also go ahead and implement in principle. So studying this policy, we're going to be asking, how did this corporate income tax surcharge impact reported business ownership via tax havens, and how did it impact offshore transparency? And in the last part, I'll go on by asking, how did it impact tax revenues and what we might construe as real business activity? So just to preview the results, the main design that we're going to be advancing here is a series of difference in differences designs that compare firms that were exposed to the policy based on being prior to the reform owned via tax havens on a majority basis, and comparing them against a set of control firms that have ownership in foreign non-havens and are unexposed to the policy. At baseline, we find that about a third of the haven-owned firms, only a third of them report true owners as verified by the provision of biographical information. And we also find that descriptively, these firms tend to be quite export intensive and very and much less profitable, which is suggestive of tax evasive activity. When we turn to the policy itself, we find that the reform induced a 30% drop in observed final ownership in havens after 5 years. That coincides with an increase in observable ownership by people in foreign non-havens. I'll also show you that we find that firms also cut intermediate ties with tax havens and decrease haven transactions on some counts. When we turn to the impacts on the other impacts on firm activity, we find that the exposed firms increased their tax revenues and their gross profits declared by about 17%, which would be consistent with a pretty large evasion elasticity of around 2. And at the same time, we failed to document any compelling changes in wage bill, investment, and firm exit. Where do we see ourselves fitting into the literature? Very briefly, I'll say a few things. Clearly, there's a large literature studying tax haven usage. I think where we fit in is that, from our perspective, there's relatively limited work that focuses on unilateral policy that involves an explicit pecuniary disincentive to engaging in tax haven usage. And at the same time, on this third group of papers here, I think we're in a setting where we're able to combine we're able to study a policy that makes pretty innovative use of a pre-existing ownership reporting environment. So we're very excited, about that. What's the data? The data that we're using here, we have 3 main data sources. The first is this business ownership registry that's established in 2012. De jure, it operates as a beneficial ownership registry, whereas in many settings there are some very empirical limitations that I'll show you in a moment. One thing that differentiates these data from other other beneficial ownership registries that you might be familiar with is that in addition to reporting, at least on a de jure basis, beneficial owners, these data also are required to report the direct and indirect linkages between companies and owners. That is, in principle, we're also able to follow a chain of owners. We combine these data with annual corporate income tax declarations, as well as another piece of data that's a bit unique to the Ecuadorian environment, and I guess increasingly less so, I suppose. That's data on the universe of cross-border transactions, which I'll bring in today just to answer the question, how do haven transactions respond to the reform? On the policy itself, so in 2015, Ecuador implemented this corporate income tax surcharge based on what is observed final ownership that's attributable to tax havens, which does not necessarily correspond with beneficial ownership in the case that the final reported owner or observed owner is, in effect, another business. The policy works in that firms with observed majority final ownership in tax havens face an additional 3 percentage points in their corporate income tax. Importantly, there's a smaller surcharge for firms that have minority observed haven ownership, which, if we have time to, we'll get into at the end. You should understand this tax policy is aiming to really accomplish 2 things. The first is to incentivize businesses to report true owners outside of tax havens, and to increase tax revenues from businesses with haven ties by presumably reducing evasion of Ecuadorian personal and corporate income tax. And this type of policy, it comes in the context of corporate income tax that's levied at 22%. So potentially, these businesses are facing about a 15% increase in relative terms in tax obligation. The way we go about studying this policy is by developing a series of difference in differences designs, which requires defining an exposure and control group. We're going to do this by defining the groups using firms' predicted exposure to the corporate income tax surcharge using their pre-reform 2014 ownership structure. So the main comparison that we're going to be advancing here, we are going to call exposed or treated firms in our main specification as those with majority tax haven ownership in 2014. And we're going to compare them against a control group consisting of other firms that in 2014 had majority foreign non-haven ownership, while at the same time having observably zero haven ownership, so as to not be contaminated or exposed to the policy themselves. This gives us 588 majority exposure firms and 3,352 control firms. And we use this comparison to evaluate the impact of the reform on the outcomes that I described on tax haven ownership, on ownership, on beneficial ownership reporting, and these potentially more downstream firm outcomes like taxes and input usage. What do these firms look like on the ground? Here I've just broken up some descriptive statistics. The first three that I want to, the first three variables that I want to talk about pertain to revenue and profit. For one, we can remark on a few things. For one, observably, these firms look quite similar, but we can also see, just looking at revenue, that these are not large firms. These are not like large multinationals. These are firms that are typically declaring a few $100,000 to a few $1 million in revenue every year. This should really underscore the intuition that this type of policy, because of its emphasis on final observed ownership, doesn't really have a bite for like large multinationals, which would engage in a very different type of tax haven usage. We also observe that most firms are declaring positive profit every year. Where the firms differ, or where the exposure and control firms differ more, is in terms of assets and exports and profitability. We could see that the haven-owned firms, in spite of being observably similarly declaring similar amounts of profit, are substantially larger, are substantially more export intensive, and at the same time are much less profitable, at least when measured by like a return on assets measure. These would be from the descriptive literature, highly suggestive of tax evasive usage of tax havens. The last set of variables pertain to ownership reporting, and we can observe that that both exposure and control firms are highly compliant with reporting at least some amount of ownership. That is, most firms are declaring nominally 100% of some of ownership, if not necessarily their beneficial owners. And we can see that when we impose like a higher threshold of true ownership reporting, compliance on this measure deteriorates considerably. You can observe that less than a third of the haven-owned firms are declaring 100% of their beneficial ownership. This number is also small for the control firms, which should also highlight perhaps some of the empirical difficulties of enforcing beneficial ownership reporting, even when it doesn't involve tax havens. So our estimation strategy, as I mentioned, is a difference in differences design that's going to compare these two groups around the reform, in which our identification assumptions are going to basically rely on a parallel trends flavored assumption. And from this perspective, and under a parallel trends assumption, these difference in difference coefficients are going to identify an intent to treat effect of the reform. It's an ITT estimate specifically because firms, if you think how they might respond, they can respond in a variety of ways. They can exit ownership from tax havens. They could stop paying corporate income tax. So really think of it as an ITT effect. The first outcome that we're going to be studying here is on ownership in tax havens. And there's an important, here's aggregates for tax haven and foreign non-haven ownership. This is just aggregates, means over time. The few things that I want to highlight here. The comparison that we're making for this set of variables is comparing tax haven ownership for the treatment group against foreign non-haven ownership for the control group. The reason being is that we want to be very careful in netting out mean reverting tendencies, and we can observe that both groups are evolving pretty similarly prior to the reform, and post reform we can observe a gap emerge between the two solid lines, which under a strategy we attribute to the effect of the reform. What does this look like when we put it in our design? Again, parallel trends, but importantly, we observe in the first year post-reform, we observe about a 10% drop in ownership via tax havens on part of the treatment group, which expands to about 20 percentage points 5 years post-horizon. In relative terms, that's a 30% drop in ownership via tax havens. We study this response a bit more and turn to a binarized version of this variable, basically whether or not there's any ownership in tax havens, and we observe a pretty similarly shaped response, indicating that this is really, what's going on here is largely extensive margin movement. You could think intuitively there's a mass of firms that are counterfactually induced to entirely exit final ownership, final reported ownership in tax havens. So very naturally, with this drop, mechanically it has to accrue somewhere else. So we turn to studying where it accrues geographically. So here, I've just taken that first difference in difference result, flipped it on the x-axis, specifically to juxtapose with the change in ownership in tax haven or in non-tax havens. And what we can observe is that the two responses nearly track each other, suggesting that all the drop in observed ownership in foreign non-havens accrues to owners in havens accrues to owners in foreign non-havens. And you could further juxtapose that with the null response for new ownership that's attributable to Ecuadorian owners. So you might ask, what about other tax haven activity? There are a few ways that we can make inference on this. For one, we could also take a look at intermediaries. So we established that the final reported ownership is changing, but perhaps the haven activity is still there. So one way of making inference on that, we can directly study whether or not there are any intermediaries in that chain in a tax haven. So here, the gray line shows the drop, that binary response, that second DD response, showing that this extensive margin movement, and we want to compare that with this result for an alternate variable that is a binarized version of whether or not there's any final ownership or intermediate ownership in tax havens. And we basically observe a pretty similar drop that's about 70 to 80% in terms of order of magnitude, basically suggesting that most of the firms that are exiting final reported ownership in tax havens are also cutting out, excising intermediaries in tax havens. We can observe this. Another way to corroborate this response would be looking at some outflows data in some of the post-tax profit allocation decision. So the first column here shows the difference in difference results for dividends sent to owners in tax havens. We observe a $20,000 drop in dividends paid to owners in tax havens. That's independently corroborated with the second column that comes from the corporate income tax form. That's basically a total drop in dividends. That's also, and you can see that where this change in profit reaccrues, it basically all just sits as retained earnings. So on ownership transparency, I'll show you one result, which is just a table pertaining to the share of beneficial ownership that is declared. So just putting beneficial ownership, that's basically the ownership share that's validated by some biographical information and a passport on the left-hand side. We can observe that on average, the exposure firms increased their beneficial ownership reported in relative terms, three different ways of parameterizing it, by about 10%, 7 percentage points in terms of the share declared, 6%, an additional 6% of firms declaring 100% of their beneficial ownership, which we all know is key. Really, I think we're all here from the perspective that this beneficial ownership reporting is key for the enforcement of tax and non-tax law abroad, and cooperating with other countries in enforcing these multilateral agreements that have very much proliferated. So in the last couple of minutes, I'll speak very briefly to firm tax and financial outcomes. So intuitively, we think that this surcharge should have an impact on business activity for a few reasons. For one, there's a mechanical effect on tax obligation. Firms remain in tax havens, or their ownership remains in tax havens. But there's also a potential quote-unquote behavioral response in the form of whether or not if firms exit haven ownership, they might lose access to evasion technology, or this policy could induce some detection threat that could also change behavior. And of course, the reform could also impose costs that reduce the activity of exposed firms. But there are also other corporate financial perspectives on what we should think of that render ambiguous what we should think the real effects of this type of reform should be on firm activity. So this table just summarizes those responses. The first column shows a 17% increase in corporate income tax payments by exposed firms. This is a pure log response. So you could compare that with column number 2, which is the binarized version of whether or not firms are paying corporate income tax. You could think of that as one form of attrition. And what we observe, very compellingly, we observe a very sharp null response. That is, firms are not stopping paying corporate income tax. We also observe a similar increase in profit declared and return on assets. Recall that initial gap in profitability that we observed at the outset in the descriptives. This response we would construe as suggesting a decrease in evasion involving tax havens. The last result that I'm going to show you, this is the last result that I'm going to show you is just on real firm activity outcomes. So here, what we construe as null results, we observe a noisy null impact on assets, but we feel quite comfortable in ruling out any decrease of the policy on whether or not there's any investment or whether there being a year-to-year investment decrease. And we also feel confident in ruling out any substantial decrease in exposed firms' wage bill or demand for labor. So given that I'm out of time, I'll move to concluding. We're going back to the question at the outset, how can countries design unilateral policies that leverage this new ownership reporting data to improve offshore ownership transparency and limit exposure to tax havens? And Ecuador was an innovative environment for studying this, in that they passed a policy that penalized beneficial ownership opacity with respect to haven usage. And what we found is that the reform resulted in a drop in observable decrease in ownership via havens that also coincided with an increase in ownership via non-havens, that's attributable to people, that also had evidently positive fiscal spillovers in terms of corporate income tax payments that also came at very little expense in terms of wage bill investment or extensive margin firm operation. So I'll conclude on that note. Thank you very much.
Hi, Elisa Casi from NHH. Thanks for the great presentation and super interesting paper. I have just a question. I think I missed, but how do they define the tax haven? So is there a blacklist or it's a tax rate? Is there any change to non-tax haven, but let's say still preferential tax treatment country, like we see in country-by-country reporting? And is there a polarization of the market in a sense, maybe if you split by effective tax rate pre-event, do we see that those that have the lowest or the very aggressive, they stick to the tax haven more because it's still profitable compared to those that are not, and then they say, okay, now it's costly, let's just drop it?
Yeah, thank you for your question. So there are a few things to unpack here. The perspectives that I started off with what does this tax aim to do? In that I mentioned that it aims to increase offshore ownership transparency and, to another extent, decrease evasion involving havens. This is almost by definition because the lists of countries that are targeted by tax havens are determined by the Ecuadorian government, basically targeting countries that feature some combination of very low tax rates, high secrecy protections, and non-cooperation with the Ecuadorian tax authorities. The point that you just mentioned on doing a heterogeneity cut on effective tax rate, we have not implemented that. I think that's a really good idea. So thank you.
Thank you, Jacob. Very interesting presentation. I was wondering, do you have any information on these tax haven firms, whether they are connected to Ecuador, rerouting sometimes locals own through tax havens, because in your motivation you framed it also like it's the interest of Ecuador to bust this, and otherwise if that's not the assumption, then I don't. Where is the interest of Ecuador?
Yeah, I'm glad this question came up. So recall this result that we do have this drop in ownership attributable to tax havens, but counterfactually, all of it reaccrues or accrues to owners in foreign non-havens as opposed to Ecuadorian owners. In respect, this might be a limitation of the policy, but if we could dig into this a little bit more, we might think that this might be an intuitive type of response for this type of policy. Think like if you're a foreign national that's operating a business in Ecuador, if you reveal to the Ecuadorian tax authorities that you in fact say a Spanish national, they show up quite frequently in our data, that you were the owner of this Ecuadorian business by a shell company, that doesn't necessarily give the Ecuadorian tax authorities any information about your compliance with Spain's worldwide personal income tax. In the world of CRS, which we only briefly intersect with, maybe there's some possibility that the Ecuadorian tax authorities can now work with the Spanish tax authorities. But point being, juxtapose that with like the null response from Ecuadorian owners. If you're an Ecuadorian person, that would reveal to the tax authorities, to your own tax authorities, I was the owner of this shell company. That would probably induce something. That would probably induce something like an audit, which you could imagine such individuals would want to avoid.
Hello, my name is Carlos Salgado from the UTax Observatory, and I was wondering if you know in which sectors are those firms that reacted concentrated, and if those sectors change after the reactions towards the reform.
I mean, a few things to say here. So, if you just like descriptives at baseline, the firms in tax havens are like a plurality of them are some between real estate and service provision, which is somewhat intuitive, but we haven't thought of putting that on the left-hand side. Intuitively, I would worry that industry classifications tend to be somewhat sticky in administrative data, and with the balanced panel, or with the panel that we have here that's fixed, we wouldn't really expect that to change. The one way of engaging with that, which I don't think we've done yet, would be to leave the panel approach and see if the composition of haven-owned firms changes. I think that could be implemented, but we haven't yet done that. Thank you.
So good afternoon, everyone. My name is Carol Seregni. I'm an assistant professor of accounting at the Wharton School, so I am the accountant in the room here. So please be nice to my colorful slides and icons. But I'm very excited to be here, so I want to thank the conference organizers for including me in the program, because I'm very interested in all the topics, and I found everything very, very, very insightful. So this is a paper that I've been working on since my dissertation. So this was my dissertation at the University of Mannheim. And today I'm going to present a few new results that I have through the revision of the paper. So you find the public version of SRN, but I'm working on a revised version, so I'm actually also very looking forward to hear your suggestions and comments. So the title of the paper is Where You're Doing Business with Beneficial Ownership, Disclosure, and Public Procurement. So let me start with why do I think it's relevant to look at this question and to put beneficial ownership and public procurement together. So when I think of, so first of all, the OECD estimates that between 13 and 20% of global GDP is spent on public procurement, so it's a pretty large market. However, a big challenge that we have faced is that both like from a theoretical perspective, but also empirical evidence shows that government officials can act to maximize their private interests rather than social welfare. And this has been shown, so for example, politically exposed people, we know that there is evidence showing that the politically connected firms are getting more contracts relative to other firms, and so on and so forth. So one solution that countries worldwide have implemented has been to impose contractual transparency. What this means is that countries have put forward reforms that now provide a basically the public with information about contract awards and notices. And basically what we have access to now is basically the procurement process in terms of what are the data that is available is, for example, which type of product is the procurement about, which companies are winning the contracts, what are the characteristics of these contracts, and so on and so forth. However, what I'm gonna kind of argue here is that once you have a lot of opacity on the winning firm side, you're actually not able to see who is actually winning the contract, basically. And we know from like the Pandora Papers, the Panama Papers, that there are powerful people that are hiding behind complex ownership structures, right? And so contractor transparency per se is not enough to figure out conflicts of interest. So what I'm gonna study in this paper is once you introduce beneficial ownership transparency, whether these can actually have any effect on the allocation of procurement contracts and outcomes. So that's gonna be my research question. Now, what do I mean by beneficial ownership transparency? The audience in the room is probably mostly familiar with this definition, but the legal definition that I'm taking here from the OECD is that a beneficial owner is always a person, a natural person, basically, that ultimately owns or controls a company or a legal entity or a trust, right? And so here, this is kind of the standard definition, but then when it comes to practice, the way that countries have implemented this beneficial ownership definition has been basically to identify the beneficial owners that have 25% of more of voting rights or legal rights, and or those that can implement control through other means, okay? So if they, for example, if they can appoint board members and so on and so forth, okay? So this is how the kind of the definition of beneficial ownership I'm gonna operate with going forward. Now, the setting that I'm going to use to address my research question is the EU Fourth Anti-Money Laundering Directive. So what happened in May 2015 was that the European Union came about with this, enacted this directive that required countries to implement beneficial ownership registries for private companies, okay? And this applied to all the EU countries at that time. Now, what was the goal, or what were the goals that the EU had in mind, were to tackle money laundering, terrorist financing, and tax evasion that we talked about today, of course. However, what I'm going to argue in this paper, basically, is that the information in these registries can also actually be used to monitor procurement contracts and the allocation of procurement contracts. And that's actually what Slovakia did by implementing a beneficial ownership registry that was targeted to the public partner of the public sector. So those people, those companies that had interaction with the government and then the contracts with the government, basically. So what's the timeline? Now, the timeline of my paper is going to be that I'm going to be using basically the staggered adoption of the registries by member states between 2016 and 2020. However, okay, so this is going to be the kind of the period that I'm going to be focusing on. As you know, a lot has changed, okay? So if you follow the regulation in this area, there's been the European Court of Justice decision in November 2022 that basically led countries to take the registries down, to close them, and make them only accessible to legitimate interest parties. But again, the time period I'm going to be focusing on is actually the implementation of these registries, and I'm going to exploit both the timing and then the accessibilities in this registry. So I'm going to take advantage of whether the registry is public or not, is accessible only through legitimate interest parties or not, or whether, for example, it's closed. Okay, and in the meantime, by the way, the US was also working on a beneficial ownership registry that has been taken down. So. Okay, so what's the beneficial ownership registry landscape that we're focusing on in this paper and that I'm kind of taking advantage of? So these are all the countries that not only have enacted the directive into law, into their law, their country law, but also have taken the steps to implement the registry, okay? And the entry into force date is the date in which they put the registries into law, but then the implementation date, actually, it's when they actually make the registry available and accessible. There is not a lot of variation, but currently in the results I'm going to show up, basically I'm going to use the implementation date, which is the day in which the registry becomes accessible to parties. And then in terms of accessibility, there is a lot of variation in terms of which countries are making the registry open for example, the UK or Slovakia or Denmark. And then there are some other countries that are making it only accessible to legitimate interest parties. And then there are some countries that have it open, but like you need to pay a fee or you need to identify with your, for example, providing your ID in order to have access to the registries. Now, the countries in gray are very important to me because those are the countries that have never enacted basically the directive into law in their own country. So for example, Italy never passed the law or implemented the registry until like last year or something like that, okay? So that's gonna be one of my control countries because it's a never treated countries for me because they never had a registry. And then I'm gonna take advantage of the not yet treated countries as part of my control group for my staggered definitive design, basically. Okay, so this is the landscape. Now, how does a beneficial ownership registry look like? I don't know if you've ever played around when these registries or most of these registries were open. If you go on, and again, this is kind of a very illustrative example, but kind of it supports what I'm trying to tell here. If you go on the Slovakian, for example, partners of the public sector's registries, and you look for this company, Agrofert AS, you find all the beneficial owners, and in particular, the Slovakian registry is very nice because they provide also information like the date of birth, the nationality of the owners, since when they were they became beneficial owners and so on. And in this case, this is not a random beneficial owners, but this is it's currently still the Prime Minister of the Czech Republic, okay? So this is a name that you may have heard of. And then what happened here is that in this specific case, what came out in the media and from Transparency International actually was that the Prime Minister of the Czech Republic was behind this company, which is called Agrofert AS, which was active in agricultural business, and they have received millions of subsidies from the EU. Okay, so when this came out, actually, they started an investigation, and there were also some social unrest in the country. Okay, this is again an extreme example, but it kind of shows the potential of the information that is shown here. Okay, that it's present in these registries. So what's the kind of framework that I have in mind and kind of my predictions here? So if you think about like the classic like Lafontaine-Tirole model of public procurement, we have the government officials, which are the public decision maker, and then we have our agents, which are the firms that I'm providing contracts to that are providing goods or services to the public and to the governments. And then there are the NGOs or the medias that are referred to as the watchdogs. Okay, so this is kind of the three actors that I have in mind when I think about my setting. And the channels that what happens here is that there is, of course, information asymmetry. We, as external parties, and the medias, for us, cannot really observe what's happening, okay, how this process is handled. And this will lead to collusive activities between the official and the firms. So here, when we talk about collusion, I'm using collusion the way they were using it in their papers, okay? So basically just the fact that they will start acting and the contracts will go to the preferred parties. What contractual transparency does is that it reduces information asymmetry. However, if we still don't know who is behind these firms, that's not going to help us a lot. But once you introduce beneficial ownership transparency, this will allow you at least to have more information about who is behind the company. So basically what I'm going to do in the paper is I'm going to combine contractual information together with beneficial ownership to see who is getting these contracts. And that's the same thing that NGOs and the media can do, okay? And what you can actually figure out here is basically red flags. Who are the suppliers that are controlled by politically exposed parties? Who are the suppliers that are behind multiple firms, okay? The beneficial owners that are behind multiple firms. And this kind of the theory that I have in mind here basically is that there is going to be some sort of reputational mechanism for which if the scrutiny is work, if the public scrutiny is at work, like in the Slovakian case, then the reputational cost of government officials to give contracts to these conflicted parties are going to increase, and therefore we should see less collusive activities happening, okay? So that's kind of the framework that I have in mind here. Now, which data am I using to conduct my research here? So first of all, I have public procurement contracts from the DigiWiz project that was financed also by the European Union. And here they collected information basically from Open Tender, and then they collected information from TED, which is the public procurement contracts data set for contracts that are larger than a certain size, and then from the national procurement websites. Then I have information from the Open Ownership Register because they have collected information on beneficial ownership from the registries that at that time were available in open data, such as Denmark, the UK, and Slovakia. But then I'm also, in this version, I'm also using now Orbis Global Ultimate Ownership and the ownership links file as a proxy to identify who is the beneficial owner of the companies for which I don't have access to the registry because they're closed or they've been taken down. I'm also going to rely on proxy for political exposure, and here I'm going to use the LexisNexis data set, and they provide access to Info4C, which is basically a compliance company that allows you to see the biography of politically exposed people. So I'm going to do name matching with this list, and then I have some further financials from Orbis too. Okay, so what's the roadmap of my study? I'm going to look at beneficial ownership information and the effect on competition in public procurement. Then I'm going to try to see if the mechanisms that I have in mind, so if the contracts are truly not going anymore to these parties that are conflicted. And then finally, I'm going to look at contract performance, where the idea here is if there was any misallocation of money beforehand, I want to see that the contract execution performance after the reform is going up, basically. So that's kind of going to connect the three parts together. So you should kind of bear with me here. I have different level of analysis depending on the test. The first one is going to be at a region product market quarter year level. Plus, I'm going to use a stack difference indifference design here, basically. So I'm going to create a different data set for each cohort in my data. The treatment of interest and the coefficient of interest is going to be the beta one here, which is basically going to turn 1 for those country product market quarter year, where after the registry has been implemented. And then I'm going to use competition as my main outcome variable here, which is proxy by the HHI. And increasing competition is going to be showing up as a negative coefficient because the HHI is from 0 to 10,000, so where a higher HHI suggests kind of basically towards monopoly. I have a sample of almost 23,000 unique markets, where a market is defined as the CPV 3-digit, which is a procurement standard method of defining markets and industries. So you can think of, for example, construction work, civil engineering is a market. And then at the regional level, so NATS2 would be like a region within a territory. I don't know, in Italy it would be Lombardy, for example. It's a region. Now, my first result here is showing you basically that relative to countries that haven't implemented the registries yet, or will implement it in the future, I find a decrease in the Arfinal index, which suggests an increasing competition for all in my first column, and then this result is actually driven by the open procedures. Now, I don't know if how familiar you are with procurement, but there are two types of procedures basically that you can have, or auctions that you can have. There are the competitive bidding one, where the process is open to anybody, and then there are the non-open one. And the non-open one is when basically the government officials negotiate to have certain parties to participate in the auction process, okay? So what we see here is that in the open procedures, we do see an increasing competition. However, this doesn't seem to happen in the negotiated procedures one. So this is kind of one of the new results that I have in the paper, because before I was only focusing on competitive bidding, which kind of seems to suggest there may be a substitution effect. So these people may actually, or this competition this increasing competition may not happen for the negotiated procedures. Okay, so the next step is that I'm going to look at the reputational kind of channel that I have in mind here. The first way I'm going to look at that is by looking at only registries that are open to the public, and where there is negative media coverage of public procurement that it's above the median before the registry is going to place, basically. Kind of like trying to identify those countries where I do expect this scrutiny to be at play. And here we find that this effect is much bigger when it comes to countries where this is happening. For example, Slovakia, of course, it's in here. And there is this clear substitution effect here. And then finally, I'm going to look at the beneficial ownership information. And I'm going to look at the beneficial ownership information in two ways. First, I'm going to use Orbis data. it's not perfect, but it's the best way in which I can proxy for beneficial ownership when it comes to countries where I don't have access to the data. And what I see, what I do here is that I look at the market share of the bidders it's always defined in the same country product market, country region product market, and I'm going to look at whether the GUO type that you have is going to be affected basically differently. So I'm going to look at whether the market share of beneficial owners that are flagged, for example, so because they're found in open sanctions dataset or in this politically exposed people list, or because they're behind multiple companies, those are the companies where I expect their market share to decrease the most, basically. If what I have in mind is happening. And this is actually what I see. So if the dot here represents the flagged beneficial owners, and the square here represents the non-flagged beneficial owners, and you see that there is a different treatment. That there is the decrease here in the market share, it's driven by these flagged beneficial owners. And now this is the same when it comes to beneficial owners that are behind multiple companies, kind of suggesting that this increasing competition is driven by the fact that these conflicted parties are less likely to get contracts. And again, this is all weighted by euro amount, okay, so volume of the contracts. And then here, I finally use the data of the beneficial ownership registries from Slovakia, Denmark, and the UK, where I have access to the data. And so I basically repeat the same analysis, but now I'm using the real beneficial ownership registries data, okay? And again, we see that the effect is driven by the open procedures when we look at politically exposed people, and the same for the multiple beneficial owners. Whereas in the non-open procedures, I don't see a clear effect, kind of suggesting that this substitution is going on. And finally, let me kind of tie up everything together. Now, if these contracts were truly a misallocation of resources, I should see an improving contract performance following the reform, okay? Now, it's hard to have a very kind of precise measure of contract performance, but the literature has been using contract modification as a proxy for that, so I'm going to be using the same here. So basically, if the contract has had any modification, there is just a variable in this open tender data set that I can use, and so that's kind of my dummy variable that it's going to be 1 if the contract had a modification. And what I see is that after the implementation of the registries, and here we're kind of back at the country region product market level, the modifications decrease following the implementation of the registries, at least for these open procedures. And this suggests that there was a misallocation of resources and that contract performance has increased following these registries, which supposedly it's a good outcome for our public procurement entities. Okay, so let me close. I have 1 minute left, so that's perfect. I have just 3 key takeaways and contribution here. The first one is that I provide the first evidence on beneficial ownership disclosure and public procurement. So, and that it does seem to be the case that beneficial ownership allows public scrutiny to be at play, and that you can use this information to prevent the allocation of contracts to pre-selected firms. Again, this speaks also to the other papers that we saw this afternoon on beneficial ownership and the fact that you may need public access to the information in order for these reforms to work, basically. Thank you very much for your attention, and I look forward to your questions.
Thank you. Super interesting and very pioneering. A quick question on the non-open contract. If you could tell us a bit, is that military mainly, and how do we think of this? Are there some good reasons also to keep some things non-open? And what would you suggest going forward on the open, non-open procurement?
So I think the non-open procedures may capture some contracts that are very specialized, so where the industry is so specialized that you do need to for these contracts to be non-open. To be honest, I haven't really looked into the heterogeneity, so I think that's a good suggestion for me to look into, like where these product markets are, and if there is a big difference between the open contracts and the non-open contracts in terms of industries, and that may actually help to speak to that. Yeah, so that's a good point. Thank you.
Hi, thanks. That was super interesting. So the mechanism for sort of transparency leading to better competition here makes sense, but I just want to understand a bit more whether it's possible to quantify the impact of having it on a public register versus not public, and also thinking about that in combination with whether the actual details of the procurement contracts themselves are public or not, because presumably to have sort of for people to feel exposed, it would need to be the case that both the existence of the contract was public and the identity of the beneficial owners was public, and having one without the other isn't going to enable investigative journalists to do their job. So
yeah. So on the first point, I do have this max scrutiny split. I don't think I have to kind of carefully look at it in terms of like quantifying the effect, because my coefficient is pretty huge there. So I need to see whether I can do something to quantify, maybe in dollar amounts, like kind of doing a better job at like quantifying the economic impact of that. But I do see that the effect seems to be driven by those countries where the registry is open. So that's for sure a factor, which again speaks to what's happening now with this legitimate interest. Like I tried to get access to this beneficial ownership registry, like as an academic. There is now a common platform apparently. It's impossible, like it's really hard. So I think, for example, Slovakia was a pioneer because they did it for procurement, and that's a very good system. So maybe I should just point out to specific examples and show how that works relative to places where that's not the case. So that's on your first point. Now, your second point was about the contracts. Yes. So my study is a joint treatment. Without contractor transparency, this doesn't happen because we need to know the contracts. We need to know the information from the contracts, and I need to know the firm. That's the other thing. Like from the open tender data set, I have to drop a ton of contracts because we don't have information about even the name of the firm that won the contract. So there is a lot going on. Again, the paper itself was kind of about once you have the two together, that's when you can figure out what's going on in terms of conflicted parties. So I can't speak to when you don't have contractor transparency because I'm not even sure how I can't tell who are the companies winning. Yeah.
Hello, my name is Miranda Evans from Open Ownership. I was wondering, and thank you so much for the presentation, I was wondering if you have any understanding or idea of sort of what the drivers of the beneficial ownership registers going online and the impacts on competition that you outlined might be. Is it just sort of fear of this being transparent, or is there potentially sort of data use by the public procurement authorities? What you might suspect those to be?
So when you talk to it doesn't seem that the public procurement authorities are using the beneficial ownership registries, and there is no, at least when I look for the different countries, there doesn't seem to be a legal obligation even to provide the beneficial owner when you are applying for a procurement contract. At least during my sample period, I think that's changing over time. And I do have a test. I didn't show it, but I do have a test where I look at whether administrative capacity does moderate the effect of the public administration, moderates the effect on competition, and it doesn't seem to be the case. So I can't speak to a learning channel, but I can't rule it out. So it does seem to be more that the watchdogs are at play, that there is this more like reputational effect coming into play. Again, I think there is a lot of heterogeneity in my findings, and maybe I just need to take advantage of and just dig deeper into specific examples. So that's a great question. Thank you.
Okay. Yes, thanks so much for the introduction, and thanks for inviting. I'm so sorry for the last minute change. Due to personal reason, I could not travel to Paris, and I'm super thankful that the team set this up in a hybrid mode. So I still got the chance to present. As announced on the program, like I'm Marcel, but I just moved from London Business School to the University of Mannheim. I'm very excited. So this is my first day representing a new institution. Where I'm a professor of accounting, taxation, and finance. So I broadened up a little bit. Until recently, I was officially only a professor of accounting at London Business School, just like Carol, and yeah, now very much looking forward to represent the broader theme of taxation again. And in that research agenda, I'm also very interested in topics concerning development and in particular transparency as well. And as you will see, I'll touch on a couple of topics related to multinational firms, which is part of my agenda, transparency and tax havens. So this is co-authored with Jinwan, who's a professor of accounting at Stanford GSB, John Gelmer, who's also a professor of accounting at UNC Chapel Hill, and a fantastic, I think, third-year economics PhD student, Iman Tagadoshi-Nejad at University of Cambridge. We simply title our paper, The Global Network of Oligarch Companies. I'll motivate a little bit. Hopefully I don't need to do too much of a job motivating the topic, but summarize what we do and then go a little bit into the data. So oligarch companies are broadly defined as those business operations that help accumulate the wealth of a politically very connected elite in different countries or jurisdictions. And our paper in particular focuses on the Russian corporate elite, the Russian oligarchs, which are also broadly defined as business tycoons, mostly due to the privatization of post-communism economic resources in Russia. And this has been the topic of investigations of many of you in the room, of journalists, of scholars, and we will connect a little bit academic research with case study, anecdotal evidence, and research of investigative journalists, as I will detail in a few minutes. Why is this a political and also social issues? Well, first of all, many people claim that the oligarchies use and the source of wealth are questionable, so we would like to understand a little bit more where this wealth is coming from and what it is doing, as it certainly contributes to global wealth inequality. Many of you in the room have contributed to this evidence here. And particularly, more recently, it's considered an issue because it helps autocracy in many home countries of the oligarchs. And in our setting in particular, quite timely and topical, it helps finance autocratic actions such as Russia's military invasion of Ukraine in 2022. And that's, of course, at the core and center of our paper, which then led Western governments and Western democracies to impose sanctions on parts of this corporate elite. There have been in the past a few individual instances because some of these individuals have violated international law. But then, in particular, since the annexation of Crimea in 2014, in particular, the US led with economic sanctions against many of the oligarchs that will be a part of our sample. And of course, then even more so, since Russia's full-scale invasion of Ukraine in 2022, we have been seeing much tighter sanctions also by many more countries outside the US, in particular the UK and the European Union, targeting not exclusively, but in particular, Russian oligarch and the related businesses, which is the core of our paper. You can also motivate this, of course, through the lens of tax havens here very illustratively with the help of a yacht as a picture. That's not the asset we are after and what we're looking at in our data, but it helps motivate the paper, and it's certainly connected. Why is this closely related to the general topic of tax haven use? Well, because tax havens help obfuscate beneficial ownership, which Carol just has nicely introduced for my presentation. And this is an issue because of obfuscating the ownership. These tax havens also help continuing the continuous provision of cash flows to oligarchs, and then the questionable actions and outcomes of the concentrated wealth, such as loans, illicit financial flows to the oligarchs and the connected elite. And they help also protect the corporate assets that actually are very often the targeting objects of the sanctions. And that's why also tax havens will be at the center of our study. So what we do is going after three broad questions, and I'm very happy to hear your feedback on that. It's still We have been working on this because it's quite intensive, but still an early paper. So let's see what you say. But we have three broad questions, and the first is very descriptive. We think we don't have a good sense so far about oligarch corporate networks, and that's why we start by asking the questions: how global are these Russian oligarch companies? Is this a more geographically isolated policy issue, or is this really a global economic phenomenon we should think about? And as a sub-question here, the core question as well: how connected are these corporate networks to Western capital, which is, of course, relevant for financial sanctions and Western capital markets? And in that space, what's the role of tax havens? So that's a very descriptive starting point. We, of course, can only answer that after constructing a database that helps us to produce a couple of stylized facts. But building off this type of descriptive analysis, we also try to go a little bit into a more policy evaluation type analysis and ask how the early US-led sanctions affected oligarch companies' global operations and assets to inform also today's policy debate as the war in Ukraine is still going on. And the debate, the jury is still out there if economic sanctions are effective enough. That's in the eye of the beholder, but we try to, of course, inform this debate using our setting, which ends in 2023. And finally, and that's probably the closest relationship or relation to the theme of the conference is, well, can tax transparency potentially help, or transparency in general, to enforce sanctions? So we're going to study beneficial ownership as well here in the cross-section when studying how oligarch companies respond to sanctions. So the key findings, in case I run out of time, our data set comprises 70 main oligarch companies. I'll define them in a second. And those 70 businesses, they have a very large global footprint, roughly 1,800 unique controlled entities. And these are heavily dispersed or held through tax havens. So tax haven entities play a huge and much bigger role for these type of businesses compared to consider the average multinational European firm. We also show that these entities, through complex networks, receive capital from Western investors through equity holdings, even after these businesses have been sanctioned. Then, after the sanctions, or exploiting sanctions as kind of a policy event here, we document that these oligarch corporate networks restructure via tax havens, which, that's kind of our main message, or what we argue, helps circumvent, in particular, corporate asset freezes as part of the sanction packages. And we also see that they wind down entities in countries with beneficial ownership disclosure regimes relative to the less transparent countries. So bottom line, it seems like these oligarch corporate networks avoid countries, including tax haven countries, that have beneficial ownership disclosure regimes. So one message of our paper is that beneficial ownership transparency, and therefore closely related to Carol's preceding presentation, that beneficial ownership disclosure regimes can help making sanctions more effective, but our results also suggest that because of the fragmented implementation of these registries at the moment, sanctions are not fully effective, and we do see these restructuring responses. And we know that this is a super timely policy issue, because as Carol has discussed, because of the European Court ruling, it's not clear that we're moving in the so-called right or more transparent direction with public registries, as many countries have actually closed down their registries. With that summary, I'd like to go into a few details of our paper. Hopefully you find it interesting. It's publicly available. There's a lot in there, including a lot in the online appendix, and I'm super happy to receive any of your feedback, even though offline or by email after the event. I think in terms of the setting, maybe I can save some time. I'll say a little bit about oligarchy and tax havens, but not so much on beneficial ownership, as Carol has delivered an excellent summary on that. The topic of oligarchs as a driver on economic force in Russia is not new. It has been actually discussed as a force of good versus bad in the Russian economy. Type of, question of, okay, what's the optimal form of ownership in Russian businesses? And oligarch-led businesses have been shown to be quite productive in the 2000s. But more recently, the question centers around illicit flows, obfuscation, and tax havens. So we do have information leaks that suggest that oligarchs heavily rely on tax havens. Here, the evidence and the media is mostly referring to personal wealth. Our paper exclusively focuses on corporate hierarchies and corporate subsidiary ownership that helps run the business, the operations of companies, rather than private assets that are also held by corporate entities. But our focus or our interpretations focus more on the corporate side of things. We have also seen in literature that tax havens are used more and more, not less, as one would maybe hope after a lot of development in terms of tax transparency regulations. And we still see and have recent evidence that tax havens are prominent destinations of global capital. Despite all of that, we argue that there's no strong systematic empirical evidence on how oligarchs use corporate structures and tax havens to keep the business running, to keep cash flows nurturing their wealth. On the sanctions side, I have already summarized where they were coming from. Our sample period particularly looks at sanction enforcement since 2014, where the US started with their Office of Foreign Assets Control to impose sanctions, and then more recently also the European Union and the UK. Well, why have the sanctions been imposed on oligarchs? Well, to impose severe consequences on Russia for its actions and effectively thwart their abilities to continue the aggression. So it's all about reducing economic wealth and cash flows to and of the Russian regime. And as the oligarchs is the politically connected elite, the assumption is that these businesses helping oligarchs accumulate the wealth also help the Russian regime, and that's why the sanctions very often target the connected individuals and their businesses. However, the literature is by now fairly extensive on the effectiveness of the sanctions around the conflict Russia-Ukraine, because it's such an important topic. However, the evidence is quite ambiguous. So on the one hand, we now have a more recent set of papers showing pretty large negative economic effects on the Russian economy on the more macro level, whereas also a host of papers suggesting that there has been a lot of round-tripping and sanction evasions, so far from conclusive to the evidence, which is important as policymakers still strive to improve the rules and discuss how to impose an effective set of rules. And that's where we try to offer some evidence on the mechanisms that potentially helps mitigate the impact of some sanctions on the oligarch companies. As I said, I'll skip the beneficial ownership regime here, as Carol has explained everything, and rather I would like to spend the remaining 5 to 10 minutes of my presentation on telling you what we do in the paper, what we can do potentially in the future, and also to give you a sense of what we are not doing and potentially cannot do. We define and detect oligarchs by, as I said, the work from the investigative consortium of international journalists, or the other way around, and the public database opensanctions.org. So they have produced a list of the connected elite in Russia and their main business. So we have an oligarch individual name and the main business, sometimes also multiple, that this oligarch is mostly owning and running, that helps the oligarch accumulate the wealth. And we are interested in those businesses. So we name match the businesses to companies in the Orbis database. So we like to find the business in the Orbis database to continue our analysis. So we use all 20 million legal entities, corporate legal entities available in Orbis incorporated in Russia to find the one main lead entity, which we identify then as the corporate ultimate owner in Orbis, and then employ something that many other papers in the multinational firm and tax planning space have been doing. We try to track down the subsidiary of these oligarch companies worldwide. It sounds as straightforward as in other studies, but those who have worked with the data know that it's not. And the key difference is what has cost us a lot of time is to really identify what is the main lead, we call it the lead company, like the main holding company of a huge conglomerate like Gazprom and Rosneft, because of a lot of restructurings over time. And then we take this entity as the corporate ultimate owner in Orbis, rather than just using the off-the-shelf global ultimate owner definition, which very often is not a very targeted solution here. In our case, as we are really interested in the corporate network of that main business that's associated with a given oligarch. And that's extremely important because the sanctions very often are targeted towards that one individual, and then crucially for our setting, all assets controlled by this individual. As an example, we have, for example, Renova. That's an oil company, a conglomerate of an oil company and an aluminium producer, has operations worldwide. And in 2014, the US started to impose sanctions on the oligarch Viktor Vekselberg and its associated business, the Renova Group. And the sanctions here mostly comprise an asset freeze. Asset freeze means that no other individual or business in the United States is allowed to transact with any economic entity associated or controlled with Renova Group and Viktor Vekselberg. Of course, this also includes banks providing loans. This includes investors potentially providing equity to any of the affiliated entities, but also suppliers and customers. So that's the idea of an asset freeze. However, to effectively enforce an asset freeze, beneficial ownership or the knowledge about beneficial ownership crucially matters. And that's why we hypothesize that oligarch companies may use complex corporate structures and tax havens to obfuscate the beneficial ownership, because if enforcing entities cannot prove that a given entity is effectively controlled or held by a sanctioned person or entity, then no asset freeze sanction can be imposed on that entity. Okay. In 2018, these sanctions were further tightened here. That's just as an aside. And the evolution of the Renova Group that we see in our data is quite interesting. For example, the parent, the level 1 holding a company, as I've discussed before, was before 2012 and before 2014 incorporated in Russia. So it was pretty obvious that this is the conglomerate associated with oligarch Vekselberg. But after the sanctions hit, this switched to the British Virgin Islands, and after 2017, the country of incorporation was Switzerland. So already at the top level, it got a bit complicated after the sanctions came in, which also led to US entities getting pushed down in the corporate hierarchy, and tax haven entities and more tax haven entities to appear in the corporate structure. So just a descriptive example of our data. I'll skip the summary statistics in the interest of time, but just to let you know, we conduct two types of analysis then in the more systematic framework here, where we run some diff and diff analysis around sanctions. One set of analysis is at the oligarch company year level. So for example, we count the number of entities that a given oligarch business controls. On average, as you see, these are quite a lot, more than 160. We can also count the number of countries they're operating in. And given the data structure we have, of course, we classify tax haven presence as well. And then to detect whether the companies restructure across countries, but within the same firm, within the same ownership network, we run analysis at the more granular oligarch company, country, year observation level. I'll skip the part why doesn't everybody know what we know, just to, for example, tell you our data set is what we think already a contribution itself. It took us 2 years to put it together. Just compare what we know here on the right with what the public knows about Gazprom, for example. Public disclosures about Gazprom just give you a sense of the following. Okay, the company has around 30 controlled entities, and only 2 are outside of Russia, and that's 1 in Austria and 1 in Serbia. That's of course
Marcel,
not the full picture.
sorry, you've just got a couple minutes left.
Yeah. I can do it in 2 minutes. Thanks. So only 2 foreign entities, that's of course not the full picture. Our data set reveals that there are almost 400 controlled subsidiaries belonging to Gazprom, 33 of which incorporate in tax haven, 1 in the US, and for example, 29 subsidiaries in the UK. Our results, maybe focus here on the right. We have a strong tax haven presence, and after 2014, the pink bars here show that there's a stronger concentration in secretive tax havens by those oligarch companies that have faced sanctions. So already pointing at some sort of obfuscation. The prime players here in terms of tax haven countries are the more secretive tax havens, Cyprus, the number 1 country here. And to spend 1 minute on the key takeaways based on our analysis is here, we see 3 things. First, there's no real effect of sanctions on the scope and also the international footprint of the oligarch companies. So the number of entities remains the same. They also keep operating in a similar number of countries. However, the presence in tax secrecy, tax havens increases strongly, less so in the only European tax haven countries, including Luxembourg and Ireland, who have beneficial ownership mandates, for example. And the third takeaway before I conclude is that if we look at this more granularly here, we do detect a reallocation after sanctions, so that's the second differences here, towards secretive tax havens. It's the third differences here, but mostly and statistically speaking only in the middle here for oligarch groups that are affected by beneficial ownership disclosures in some countries in Europe. We have more analysis in the back end of the paper stressing these takeaways. I hope that made sense, and sorry again for appearing only online. Looking forward to your pre-feedback. Thanks a lot.
Thanks, Marcel. We're going to take 1 or 2 questions before breaking.
Thank you, Marcel. Very interesting, and a big amount of work on the data. I was just curious, can you go back to the Cyprus result? And I was wondering if this is the European Cyprus or if this is the bit controlled by Turkey, because you showed your result also that there was no effect on EU, right? So that's why I was curious if that is the northern part of Cyprus.
You mean Cyprus? Well, I would need to check if it's incorporations in Nicosia or elsewhere. But I think this can also be considered the European Cyprus, but still, even being the European Cyprus, in the sample period, Cyprus had not implemented the beneficial ownership registries and was one of the first to close down in 23 after the court ruling. So we considered the secrecy Cyprus, despite not fully being able to answer your question.
Facilitating, an oligarch's continued operations, because you can be cut off from dollar clearing, you can be cut off from correspondent connections to the U.S. So I'm curious, is there any way to tease apart which havens are more connected to the U.S., especially in the post-war world? Which ones are less reliant on the dollar itself?
Absolutely. I don't have an answer to the question. I can only answer would be possible with our data, as we do also track in which position of the ownership tree a given entity is located, what the direct holdings are. So we could tell you, okay, we have a tier 4 subsidiary which is seemingly responsible for US operations is this now controlled by or held with an intermediary in a given tax haven, A or B, or not, and how this changes over time? That would be possible.
All right, thank you so much. Another round of applause, and then we're going to break for coffee outside. Thank you, everyone.